The Supreme Court is currently reviewing a case that challenges the National Firearms Act and its restrictions on short-barreled shotguns. The Trump Department of Justice just filed a response that's getting a lot of attention, so let's break down exactly what happened. Before we get started, if you want to support the channel, one of the best ways to do that is to subscribe. Today we're talking about a major NFA challenge case that's sitting in front of the Supreme Court right now. This case is called United States v. Rush, and it's a direct challenge to the NFA and its current restrictions on short-barreled shotguns. The challenge asks the Supreme Court to rule that the NFA's restrictions on short-barreled shotguns are unconstitutional under the Second Amendment. The petition also emphasizes how the Supreme Court needs to step in and fix all the lower court defiance and confusion that's been happening around what types of arms are actually protected under the Second Amendment. Here's what happened. The Trump administration initially sent a notice to the Supreme Court waiving their response to the petition. They said they wouldn't respond to this NFA case unless the Supreme Court specifically ordered them to file a response. Well, the Supreme Court did exactly that. They ordered the response, and the Trump DOJ just submitted it. In their response, the Trump administration argues that the Supreme Court should deny review of this case. Their reasoning is that the NFA has at least some circumstances where it could be applied in a constitutional way, and therefore this case should survive what's called a facial challenge. There's some legal nuance to that argument, but that's one of their main points. But here's what's even more interesting. They also argue in this brief that the fundamental question of whether short-barreled shotguns are arms and therefore protected by the Second Amendment is a question that should be answered in a different case, not this one. The Trump DOJ is calling for the Supreme Court to take up a state AR-15 ban or rifle ban case to address this topic, instead of dealing with the more complex and somewhat unclear issues surrounding short-barreled rifles. The Trump DOJ argues that a state rifle ban case would be a better vehicle and a clearer way to answer the question about what types of arms are protected by the Second Amendment. They're saying that once the Supreme Court does that, it will give better guidance to other courts on how to handle and address this short-barreled rifle question. Now, for those who aren't familiar with this case, let me give you the background. This NFA short-barreled rifle case involves Mr. Rush being in possession of an unregistered short-barreled rifle. The case started in February 2022 when a police officer saw Mr. Rush, who didn't have a valid driver's license. It had been revoked. The officer saw Mr. Rush pull into a driveway with his truck, get out, and walk to a courthouse for an appearance. After leaving the courthouse, Mr. Rush walked across the street to a nearby apartment complex and went inside. About an hour later, Mr. Rush's sister left the apartment, got into the truck, and drove away. The police officer followed the truck, pulled it over, and talked to the sister who was driving. The officer asked her to call Mr. Rush and have him come to the vehicle. While that was happening, the police officer looked into the vehicle and saw what he believed was marijuana in the center console. Because of that, the officer searched the rest of the vehicle. Mr. Rush arrived right as this was happening. When Mr. Rush got to the truck, he opened the back door and reached to grab an object on the floorboard. After a brief struggle with the police officer, Mr. Rush was arrested. They found a loaded short-barreled rifle on the floorboard of that truck. Mr. Rush later admitted that he intended to grab the rifle and run away with it. Because of this whole situation, Mr. Rush was charged with possessing an illegal short-barreled rifle in violation of the NFA. On review, the district court denied his motion, concluding that short-barreled rifles are dangerous and unusual firearms, and therefore not protected under the Second Amendment. This was then appealed to the Seventh Circuit, which affirmed the district court's decision. The Seventh Circuit relied on the Supreme Court's earlier ruling in United States v. Miller. They found that Miller remains controlling precedent and that the NFA's restrictions are consistent with the historical firearms regulations mentioned in the Bruin decision. In response to all of this, Mr. Rush filed his cert petition to the Supreme Court. Mr. Rush also has support from the NRA. The NRA argues in this petition that since the Supreme Court issued the Bruin decision, courts across the country have struggled to answer the many questions that came from the court's new analytical framework. Specifically, the debate about what constitutes a bearable arm covered by the Second Amendment has become relevant again. They argue that this case presents several issues that are dividing lower courts and that it's a suitable vehicle for the court to clarify what arms the Second Amendment actually protects. Now, like I mentioned earlier, the Trump DOJ originally waived the right to respond to the petition, but the Supreme Court ordered them to file a response anyway. The Trump administration recently filed that response, and they first argued that the petition should be denied because the NFA is facially constitutional. They argue that there are some valid applications of the NFA to the point where it doesn't completely violate the Second Amendment, and based on that, it should survive a facial challenge. There's some legal nuance around what the Supreme Court has said about facial challenges, but the more important part of this case is what the Trump administration argues about these types of arms bans and what they want the Supreme Court to do to clarify what arms are protected. The Trump DOJ argues that this case is not the right vehicle for reviewing and deciding what arms are protected under the Second Amendment. They argue instead that the Supreme Court should take up a state rifle ban case to answer that question. The Trump administration states in the brief, Mr. Rush instead asked this court to grant certiorari to resolve a variety of other analytical issues, such as the meaning of the word arms in the Second Amendment. Some of the questions that petitioner raises may well warrant review in an appropriate case, but this case would be a poor vehicle for addressing those issues. Other types of cases, for instance, cases involving state laws banning AR-15 rifles, would provide better vehicles for clarifying the appropriate framework for discerning what types of arms the Second Amendment protects. Based on that reasoning, the Trump DOJ asked the Supreme Court to deny review of this case and potentially grant review to a different challenge instead, like an AR-15 rifle ban case. If that happens, it would be interesting to see if the United States government and the Trump administration decide to file an amicus brief in a different case that's currently pending and seeking Supreme Court review, like the Beavis versus Cook County rifle ban case that we've talked about on the channel before. That case is currently pending in front of the Supreme Court and seeking review. We've already seen the Trump DOJ do something similar in supporting rifle ban cases, like the ones in the Seventh Circuit dealing with the Illinois rifle ban law known as PICA. In that Seventh Circuit challenge, the Trump administration and attorney Harmeet Dillon actually joined in the oral arguments to argue against the state of Illinois' bans on rifles and magazines. So again, this is a very important challenge that's moving forward in the Supreme Court right now. The Trump administration filed their response arguing that the petition should be denied, but they also argue that the Supreme Court needs to take review and address these other questions about what constitutes protected arms in something like a state AR-15 rifle ban case. This is a really interesting development. We're going to see how this plays out and how it moves forward. As we get more information, I'll keep you guys updated. If you found this video helpful and you'd like to support the channel, one of the best ways to do that is to subscribe. But as always, thank you so much for all of your support.